In 1803, Marbury versus Madison. It was the first time law passed by Congress ruled unconstitutional. So it's basically the first time they found that they can overrule certain things that did not apply to the Constitution and were marked unconstitutional. So basically, it was the first time that anything like this had happened. So it was a big milestone for the Supreme Court. In 1857, the Dred Scott versus Sanford. It was basically a guy, Dred Scott, black. He was black, black male, and this was during the slave. It was 1857. He was living on free soil, so he believed that he was a free citizen, and it was ruled that uh, blacks are not citizens, and that he had no right to sue in federal court. In 1954, the Brown versus the Board of Education. It was ruled unconstitutional to make different racial schools. It was believed to affect the learning of the minority children, and they did not want that to happen. So they stopped the different racial separation during schools. In 1973, the Roe versus Wade. Woman's right to choose over an unborn child's right to birth. It was basically about abortion, and it was the case that basically started the whole whether or not it was pro-choice or pro-life, which is a big controversy with Democrats and Republicans. Pro-choice, which is, it's your choice, you got to do what you want, it's between you and your doctor, or pro-life, abortion should be illegal, and all children have the right to live. Okay, in 2003, the Lawrence versus Texas. It was unconstitutional. A Texas law prohibiting sodomy. It legalizes the same-sex consensual activity in all U.S. states and territories. So this was basically one of the first gay marriage, or not gay marriage, but gay rights ones. They basically can go in public and act like partners in their own time. It didn't really have too much to do with marriage, just the fact how they were acting in public, I guess. And then in 2006, we have Ayotte versus Planned Parenthood. This is another abortion one. The doctors cannot work on abortion with a minor until 48 hours after the parents have been notified. So there was a certain time limit as to when they could either operate or work with the minor. Once you're past the minor age, it was kind of your choice, but when you are a minor, the parents had to be notified within 48 hours before you could start working on that. In 2007, the Gonzalez versus Carhart case. Courts no longer required that regulation of abortion must protect the mother's health. So the mother's health was not an issue after that. The court decided that if it was going to be done, it was for the child and not the mother. So the mother's health was pretty much unimportant, sorry. In 2008, the District of Columbia versus Heller. The Second Amendment does protect an individual's right to possess a firearm unconnected with service in the militia. So it's basically people's right, without serving in the military, to protect themselves with firearms, basically whether they can carry them or not. So it's basically just as citizens without any connection to the military, and it was their right to carry those weapons. Then now we are in 2013, the United States versus Windsor. It's the 1996 Defense of Marriage Act is unconstitutional. The DOMA, Defense of Marriage Act, they ruled that unconstitutional. So the 2013 Supreme Court cases were gay marriage based, and that they ruled that the Defense of Marriage Act was unconstitutional, and it wasn't overruled, but they overruled the act. Another one in 2013, the Hollingsworth versus Perry. Some sex marriage opponents or same-sex marriage opponents in California did not have standing to appeal the lower court ruling that overturned the ban known as Proposition 8. So the California's ban on same-sex marriage, Proposition 8, was overruled, and in California you are able to do what you do. So there's no more ban on it, and they are free to live.